International Bill of Human Rights. Later on, the Universal Declaration of Human Rights was bifurcated into two separate covenants. Namely, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. The human rights and freedoms contained in the Universal Declaration have been further developed and elaborated upon in these two covenants. Both the covenants were adopted by the UN General Assembly in 1966 and came into force in 1976. In addition to the above two detailed covenants, two optional protocols to the International Covenant on Civil and Political Rights were also adopted by the UN General Assembly. The first optional protocol was adopted in 1966 itself, while the second optional protocol was adopted in 1989. The first optional protocol provides for the submission of complaints by individuals whose human rights have been violated by a state party. The second optional protocol, on the other hand, advocates the abolition of the death penalty. The Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights and its two optional protocols, and the International Covenant on Economic, Social and Cultural Rights constitute what is now widely regarded as the International Bill of Human Rights. Other international conventions. The International Bill of Human Rights has been further supplemented by various other international treaties, conventions and declarations. They are usually regarded as human rights instruments. They are specialized in nature and related to either a particular human right or to a specific vulnerable group. The important among them are as follows. Convention on the Elimination of All Forms of Racial Discrimination, 1966. Convention on the Elimination of All Forms of Discrimination Against Women, 1979. Convention Against Torture and Other Cruel, Inhuman or Degrading Treatment or Punishment, 1984. Declaration on the Right to Development, 1986. Convention on the Rights of the Child, 1989. Convention on the Protection of the Rights of All Migrant Workers and Members of Their Families, 1990. Convention on the Rights of Persons with Disabilities, 2006. Human Rights in India. The Constitution of India has a rich content of human rights. The preamble, the fundamental rights, and the directive principles of state policy reflect the principles and provisions of the Universal Declaration of Human Rights, 1948. The four ideals of the preamble are aimed at the promotion of human rights. They are as under: justice in social, economic and political spheres, liberty of thought, expression, belief, faith and worship, equality of status and opportunity, fraternity assuring the dignity of the individual. The fundamental rights under Part 3 of the Constitution contain an elaborate list of civil and political rights divided into 6 categories. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. The directive principles of state policy in Part 4 of the Constitution comprise economic, social, and cultural rights. They can be classified into 3 broad categories, viz. Socialistic principles, Gandhian principles. 3. Liberal intellectual principles. Besides the fundamental rights included in Part 3, there are certain other rights contained in other parts of the Constitution, for example, the right to property in Part 12 of the Constitution. In the course of time, The Supreme Court has also expanded the scope of human rights contained in the fundamental rights. It declared a number of human rights as integral part of fundamental rights, though they have not been specifically mentioned in Part 3 of the Constitution. The examples of such unenumerated fundamental rights are right to health, right to speedy trial, right against torture, right to privacy, right to travel abroad, right to free legal aid, and so on. In addition to these, the various laws enacted by the Parliament and the state legislatures contain a number of human rights, particularly for the vulnerable sections of the society. Some such laws are the Bonded Labor System Abolition Act, the Protection of Civil Rights Act, the Persons with Disabilities Act, the Minimum Wages Act, and so on. Finally, the Protection of Human Rights Act 1993 defines human rights in India as the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution are embodied in the international covenants and enforceable by courts in India. Further, it also defined the International Covenants as the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights adopted by the General Assembly of the United Nations on the 16th of December 1996 and such other covenant or convention adopted by the General Assembly of the United Nations as the central government may, by notifications, specify. The Indian government acceded to these two international covenants on April 10, 1979. The Constitution of India and the laws of Parliament as well as state legislatures not only consist of several human rights but also provide for the establishment of national and state commissions for the protection and promotion of those rights. National commissions related to human rights. Name of the commission established under 1. National Commission for SC's Constitution, Article 338. 2. National Commission for ST's Constitution, Article 338A. 3. Special Officer for Linguistic Minorities Constitution, Article 350B. 4. National Human Rights Commission. The Protection of Human Rights Act 1993. 5. National Commission for Protection of Child Rights. The Commissions for Protection of Child Rights Act 2005. 6. National Commission for Women. The National Commission for Women Act 1990. 7. National Commission for Minorities. The National Commission for Minorities Act 1992. 8. National Commission for Backward Classes. The National Commission for Backward Classes Act 1993. 9. Central Commissioner for Disabled Persons. The Persons with Disabilities Act 1995. State commissions related to human rights. Name of the commission established under 1. State Human Rights Commission. The Protection of Human Rights Act 1993. 2. State Commission for Protection of Child Rights. The Commissions for Protection of Child Rights Act 2005. 3. State Commissioner for Disabled Persons. The Persons with Disabilities Act 1995. 4. State Commission for SCs and STs Act of the State Legislature or Executive Resolution of the State Government. 5. State Commission for Women Act of the State Legislature or Executive Resolution of the State Government. 6. State Commission for Minorities Act of the State Legislature or Executive Resolution of the State Government. 7. State Commission for Backward Classes. Act of the state legislature or executive. Resolution of the state government. Thanks to you for watching. Like, share, subscribe, for more such videos.